Good evening, everyone, and welcome. On behalf of the Constitutional Law Society at BITS Law School, we are delighted to host you today. My name is Prashant, and along with my colleague Anubhav Tiwari, we both together teach Constitutional Law at BITS Law School. We also serve as the faculty advisors of this Constitutional Law Society. It's a student-led platform which is working on scholarship with regard to Indian constitutional law. This month is particularly special for all of us. We are celebrating 75 years of the adoption of the Indian Constitution, a rare milestone for any constitutional democracy to have achieved. I mean, for those who follow the functioning of constitutions, they may be aware of the seminal work with regard to endurance of constitutions. The average age has been found to be 19. So for us to have, I think, completed 75 years is certainly a rare milestone. So as part of this celebration, the society is organizing several activities. It was earlier this month, we had the honor of hosting Justice Muralidhar, and where we organized a book talk, and the Constitutional Law Society also found this as a good opportunity to launch its newsletter, its first edition of the newsletter, which is the Constitution Chronicle. And let me also take this opportunity to plug our forthcoming blog, which is going to be active very soon. We are going to be hosting it on Substack. So this is something we'll be sharing with everyone very soon. But now to the most exciting part of today, the conversation with a very special guest. We are delighted to welcome Mr. Yashraj Singh Deora, senior advocate at the Supreme Court of India. Mr. Deora has had an illustrious career at the bar after completing his legal education at the Campus Law Center, Delhi University. He was designated as a senior advocate by the Supreme Court in 2024. For the students listening today, you should know that this is a very rare accomplishment to be designated by the Supreme Court of India, and it is a very high recognition of excellence in the profession. But I mean, aside from his other accomplishments, we are here today to focus on his crucial role in the case, which is already being recognized as a landmark judgment. That is Jane Kaushik versus Union of India. Mr. Deora appeared pro bono for Ms. Jane Kaushik, a transgender woman who was terminated from multiple private schools solely because of a gender identity. This case not only challenged her dismissal, but also brought forward the systemic issues with regard to the implementation of the Transgender Persons Protection of Rights Act, which came out in the year 2020. The act title says 2019, but the law got implemented in 2020, and the rules also were formulated in 2020. I mean, there are a range of issues which the transgender community has raised with regard to the law. The constitutionality of this particular law is also under challenge. The case hasn't come up for hearing, but the constitutionality of this particular law is still, to be discussed. But in this particular case, the court was confronting the discrimination faced by a transgender woman from private actors, and also dealt with the absence of mechanisms with regard to addressing such cases of discrimination. As anyone who would go through the law, they would find that there is an anti-discrimination section. However, to get it enforced, be it from state agencies or from private actors, it's been a very difficult subject. In this judgment, I mean, there are several new areas which have been identified. Several new landmark concepts have been laid down. The court has, of course, built on the concept of indirect discrimination. It has, recognized the concept of reasonable accommodation to be extended to transgender persons, something which was usually only done for persons with disability. So these are going to be some of the themes that we are going to explore today with Mr. Deora. Sir, I mean, you've already spoken a little briefly about this particular case. So if I may begin on a personal note, like to understand, like, how did you get involved with this particular case, and what was the process of, developing the argumentative structure, and how do you think that the court has addressed it? I mean, I'm sure in the judgment actually begins with recording your submissions and the various issues that you laid down with regard to the implementation of the law as well as the rules. So, if you'd like to share how you went about preparing the arguments.
Yeah. So good evening to everyone. The case came to me through CJLS, which is Center for Justice, Law and Society. It's a center run by one of the professors at JGU. And they also run a legal aid clinic where they work for the rights of transgender persons. And from time to time, they do approach me for legal advice on how to implement rights, how to enforce rights. So they had brought Jane's case to me when she was terminated from the first school after I think after 6-7 months of her termination from the first school, and she was finding it difficult to find employment in any other school. So the first aspect that when you see these cases is that it's an employer-employee dispute protected by the Transgender Persons Act, that there should be no discrimination. So that's the only right you are looking at originally. So if we had looked at it in that restrictive sense, we would have been stuck in a civil litigation in a civil court, which would have taken years to conclude. So I had suggested at that point of time that she approaches somebody in Allahabad, because this was a school which was established in UP. And I had suggested that this can be made into a larger issue, and you can approach the writ court, because it's not a simpliciter case of employer-employee, when that's how originally everybody was looking at it. But when I saw it, I thought it was a clear case of constitutional rights and duties of the state that the state was not complying with. In the meantime, Jane happened to get employment with another school, which was in Gujarat, and then the same, there was a repetition of the discrimination. In this case, it was on the face of it, because after she was employed, she reaches the school. They don't allow her entry in the school, and they say, sorry, we do not employ transgender persons. So when that happened, and Jane came, as in when CJLS brought that issue back to me, I said, now it's a fit case to go to Supreme Court, because now it spans 2 states. We will not be told to go to a particular high court, because otherwise, as you know, that if it's a issue, even if it's a constitutional issue, the first courts that we have to approach is the high court. But in this case, because there were 2 states involved, that gave us the opportunity to approach the Supreme Court immediately, saying that rather than having 2 separate cases at 2 different high courts, we should be allowed to approach the Supreme Court. So that was one of our strategy in the sense it was the factual basis which gave us the opportunity to approach the Supreme Court. But our strategy was very clear that this has to be a writ. It cannot be a civil suit. And as you know, so that's why we approached the Supreme Court under 32. And we raised the issue of initially, because by then we already had the benefit of Kaushal Kishore, which said that there are certain fundamental rights which will have horizontal applicability, and even private actors can be brought to within the jurisdiction of a writ court. We had the benefit of that, but we wanted to be absolutely sure that the writ would be maintained. And when we looked at it, it was more than evident that the state which had the duty, the first duty to implement these laws, had not. So from that jurisprudential angle, we looked at the Hoffeldian analysis, right duty paradigm, and approached it from that perspective, that though I have a right, unless you say that the state has a duty, corresponding duty, and not only the duty has to be implemented, it shouldn't be just on paper. So that's the legal strategy we adopted to approach the Supreme Court.
So just to thanks a lot for giving the background story of how this happened. Certainly, I mean, I've seen the more recent interviews which Jane has done describing her horrifying experience of facing discrimination in multiple states, not just one, and somebody who is very well accomplished, to be employed anywhere as a teacher. But yeah. So to probe a little further on the lacuna or the problems that you were able to identify in the implementation of the Transgender Persons Act or the rules, what were the specific arguments which related with the law or the rules?
So what really helped is, again, because CJLS works very closely with the trans movement, the right for the transgender persons. And so they were, we get the benefit of what's happening on ground. Otherwise, we are, as lawyers and as judges, we are slightly disassociated from the reality of what happens on the ground. So that benefit we got, that as in the benefit that I got was that the Act, though it provides for various safeguards, because the first thing, as a lawyer you see is you'll see the Act, you'll see the rules, you'll say that a particular safeguard has been provided. Why did you approach this particular authority? So in this case, there's a grievance redressal commission. Every establishment is supposed to have a grievance redressal officer. There was no such thing in the case of both the private schools. There was no grievance redressal officer. More importantly, what we found was that though the Act specifically provides for the state and the center to come out with policies, various policies, including to sensitize the private establishments, include employers, private establishments, schools, etc., on the rights of transgender persons. No such act had been taken by the state. Secondly, even though a right was provided under the Act, Section 3 and Section 9, both of the Transgender Persons, the Right of Transgender Persons Act, specifically provide a duty that there should be no discrimination. And in fact, if you see the language of the Act, it's negatively worded. That means it's mandatory in nature. Again, what we sought to argue based on that was that these are only a manifestation of Article 14 and 17 and 15, as well as 21, because right to life with dignity. We also brought in the argument of Article 17, borrowing from the judgment in the Indian Young Lawyers Association, which was pertaining to the Sabrimala temple. So we borrowed from the reasoning over there on Article 17, because otherwise Article 17, as you know, we've always understood untouchability in the context of caste. But the Supreme Court, for the first time in that judgment, expands it to say other socially marginalized communities. Also, there could be a concept of untouchability, and therefore we brought that argument also in, tying it up with Section 3 and Section 9. And then the duties under Section 8 of the state to formulate policies, read with Rule 11. If you see Rule 11 of the Transgender Persons' Right Rules 2020, there's a specific requirement of formulating policies. None of that had been done on ground. So that became a way to approach the court, formulate our arguments to say that, again, that this is, after NALSA, though you've followed the judgment only in letter but not in spirit, because this is apart from the fact that there are some problems with the Act, etc. But in this when we approached the court, we didn't want to expand the argument to challenge the Act, because we thought that would bog down the litigation. Challenge to the Act means it's a long drawn litigation. We thought it would be better to go and seek implementation of what already is there. And therefore, we specifically sought a mandamus in this writ petition, that apart from dealing with the aspect of discrimination, there should be a mandamus to implement the Act and the rules.
I mean, that certainly seems like a strategy which has worked. It was very interesting to see how, and I hope the students make note of it, that how do you basically turn an individual discrimination case, which could perhaps be dealt with in a different manner, but you identify a systemic problem and use constitutional law arguments to resolve a bigger problem here, which is very much out there. There are several problems with regard to the implementation of the law. There is supposed to be a National Commission for Transgender Persons, which is a body which is just, existing. You hardly find any effect of the functioning of this particular, institution which has been created by this particular law. Similarly, the judgment also notes the several, issues that you have identified with regard to the implementation. So, this brings me to the idea of how you have, connected this in terms of from being a case of a direct discrimination, but also how you've invoked indirect horizontality here and indirect discrimination here. Because this could very well be seen as a case of, a private actor discriminating against someone on the basis of the gender identity, which could be dealt with in a difficult manner. But how do we basically involve different state actors and how we make them as party? So if you could walk us through the journey, it'll help the students really understand how we basically build a case and engage, state agencies with regard to any fundamental rights violation.
So, as you know, traditionally we've always considered Part 3 rights as enforceable only against the state. That has been our traditional or conventional understanding of the fundamental rights. But all constitutions, like now, well entrenched in our jurisprudence that these are living documents. You can't read them in a manner, fixed at a time in history. You have to see that they meet today's our standards of society as we are evolving. Now, keeping this in view, and especially how the state's functions over time has changed, how we have privatized most aspects, what would traditionally would have been state functions. So keeping in view these aspects, so Kaushal Kishore becomes the first watershed in so far as this horizontal applicability of fundamental rights. That means that there are certain articles in the Constitution which Kaushal Kishore interprets based on the language used in those articles, where it is clear that it is not specifically against the state. The protection under the Constitution is a protection where they are recognizing the right in general, and it is against everyone. It is not against only the state. So the right take for example Article 14, Article 17. Now 17, untouchability is not only practiced by the state, it's mostly practiced by individuals. Now, so these are things which the court said that they can be enforced against private actors also. Private actors cannot escape by simply saying that, sorry, this is the wrong jurisdiction that you've approached, and fundamental rights are not enforceable against a private actor. So we took that aspect. Then we tied up section, we said that these horizontal duties, which are otherwise provided by the Constitution, because every right, like I said, every right will have a corresponding duty. So we said the Constitution provides for horizontal duties on private actors. We said it is those horizontal duties of which are recognized, and if you specifically see the Transgender Persons Act, again, the protections which are there, again, Section 3, Section 9, these are nothing but an extension of your rights under Article 21, Article 14, Article 17. So we argued on that basis that this is these private state actors, that means both these private schools, cannot escape the jurisdiction of the court or cannot escape their duty by simply saying they are private actors. And they will have to satisfy their duties, because otherwise these rights become, like I said, over a period of time, as we move towards more privatization, etc., these rights, our fundamental rights, will be rendered mere paper. So therefore, I think Kaushal Kishore was the watershed, and now the applicability of it in Jane becomes, I think, the route for further litigation on these aspects wherever fundamental rights are breached by private actors.
Very interesting, sir. I mean, certainly there is a lot of commentary which has been written on the impact of Kaushal Kishore judgment, but here we are certainly seeing a positive effect of the same. Tied to the concept of indirect discrimination, I also wanted to understand how the whole petitioner team, including yourself, was able to bring in disability rights perspective or the concept which is more central to the disability rights movement, that is of reasonable accommodation. Because I see that in your arguments you have relied on judgments where reasonable accommodation was denied to persons with disability, and how basically we tie this to in a case of violation of transgender persons' rights.
Yes. So how we looked at it, why we wanted to bring in reasonable accommodation is one of the, generally when you take a matter to court, you'll always have the other side raise various allegations, right, to try and cover up something that they've done. Though in this case, the court found that one of the schools in UP did not discriminate. But we had brought in that concept of reasonable accommodation with regard to Jane's tenure at that particular school. And we had said that you have to understand various aspects of being a transgender person, because we can't look at it from the eyes of cisgender, right? We may have, because we have our own privileges, we may not face that kind of discrimination. So we said that the argument that we sought to bring in is, take for example, if you are making an allegation that somebody is standing up or trying to enforce their rights, or is getting angry about something when their rights are being violated, especially keeping in view when they feel discriminated, can that become a ground of termination? Or though in this case they didn't put it on that, but while in their replies they had sought to allege that she would get angry, etc. So we sought to bring that aspect of it. We borrowed from the jurisprudence that had already been laid down, though the Right to Persons with Disabilities Act specifically provides for reasonable accommodation as a requirement of the statute itself. But we thought that again is something that flows from Article 14, because you cannot treat unequals as equals. You will have to provide for something so that you bring them on the same playing field. Where you have a marginalized section of society, you can't expect them to immediately be at the same level playing field as any other privileged class. So therefore, the argument of reasonable accommodation was brought in with that concept. We borrowed from the jurisprudence which had already been laid in the right under the rights to of persons with
Persons with
disability.
disability.
Yes, and
Right.
there was specifically judgment of Justice Chandrachud on that particular case. So we borrowed from that, and then we sought to argue that you will have to provide reasonable accommodation. Again, we took it back to NALSA, because NALSA also had recognized this, that there had been systematic discrimination. And the only way you can now remove that systematic discrimination is, one is provide for reservations, but also provide for reasonable accommodation in any law that you bring about. So though the law doesn't, the Transgender Persons Rights Act doesn't expressly provide for reasonable accommodation, but we sought to read into it that reasonable accommodation would be a facet of it.
I think this is one of the most significant contribution of this case. I mean, to students, perhaps, I mean, we haven't covered this in sufficient detail, perhaps, while discussing Article 15. And there is a reason for it also. Disability is not a expressly protected ground under 15. However, we've tried to read into, and we primarily consider, this as a statutory discrimination. We approach it from a statutory discrimination lens. But there is a huge demand by the disability rights movement to read disability, within Article 15 and also recognize this as an express ground. And this is where I wanted to just add a little bit, to the concept of substantive equality, that the idea of coming up with a reasonable accommodation related measures by state is a feature of extending substantive equality measure. First of all, the very idea of coming up with a specific law regarding rights of persons with disability is a measure to extend substantive equality and reasonable accommodation. There are various ways by which state as well as non-state actors need to create the workplaces more conducive, more accessible to persons with disability. And in the context of transgender persons, certainly this concept very much applies. However, it wasn't recognized as such, and this judgment goes into sufficient detail with regard to extending reasonable accommodation to persons with transgender persons.
In fact, it says that
right.
They've put it on human rights. They've said now reasonable accommodation is one of the aspects of human rights. Justice Patiwala, in his judgment, he borrows from foreign jurisprudence, especially EU, how the law and reasonable accommodation has developed there. And he puts it on the aspect that now this is an aspect of human rights. Every time you consider human rights, you will have to consider the aspect of reasonable accommodation.
Not as a huge sidestep, but to students, like when they start reading international law, you'll come across various reports by different UN treaty bodies, because our obligations under various international human rights convention gets reviewed frequently, and the Committee on Rights of Persons with Disability frequently issues these recommendations to the government of India to basically extend its reasonable accommodation related measures, and also disability being read an express ground of under the anti-discrimination provision in the constitution is also a frequent recommendation that the government of India gets every now and then, but rarely is able to meet this. Maybe now we can perhaps move on to this one more new concept which we find, or a relatively unexplored concept that we find in the judgment with regard to omissive discrimination. And here, sir, perhaps you could share a little bit about what the Act really wanted to, create in terms of grievance redressal mechanism, be it at the state level or at the central level, and how this has been, state inaction has perhaps been, created, and this new concept of omissive discrimination has been invented. So if you can delve a little bit deeper into this concept.
Yeah, so I think this judgment will have an impact, because I think for the first time, the court has put it under a doctrinal head, I would say, of omissive discrimination. We've not, as in Supreme Court has in the past, not specifically put it on omissive discrimination, but Supreme Court has in the past also stepped in when the court has found that rights of persons were being trampled upon. So Vishaka being one of the first cases, as we know. Though the court doesn't put it on actively on omissive discrimination, the court says that this we derive the rights because the India had signed the treaty, and therefore the court said that we can therefore lay down guidelines. But if you think about it, what the court was doing in Vishaka also was something similar. The court was protecting the rights of women who, so that there's no sexual harassment at workplaces, there's safety of women at workplaces. So this was, and the court always steps in when the state fails to act, because what is omissive discrimination? How the court has now, like I said, now it gets a doctrinal head under which it gets classified. For the first time, the court is classifying it as such, but we can find that the court in the past has also done such things without classifying it. So for the first time, the court points out that how, and I think partly also in Colonel Nitisha, the court has, again, not put it under omissive discrimination, but the court says that, where you permit a status quo to remain, you don't change with the times. What you're doing is the state is then violating the rights of certain category of persons, or whether they are a marginalized section or belonging to a particular sex, caste, etc. So when you don't act upon, when the state does not perform its duty, though actively there's no discrimination, there's no act of discrimination by the state. It's not like the state has come out with a law where the state is saying that we are going to we are only going to permit a particular class to be employed in a particular organization. That would be active discrimination, and you would go to court in the classical test of reasonable, whether the discrimination, there's reasonable nexus to the object that the act seeks to achieve, is the classical test that was applied.
Right.
But now under 14, the other test that they apply is equality before law, because one is, there are two concepts under Article 14, as you know. So the second aspect, where it says equality before law, that brings in the concept, according to me, of even omissive discrimination, because equality before the law means that that legislature has a constitutional duty to act positively to safeguard everybody's rights. So the moment you recognize a marginalized section of society, you recognize that there's a particular group that may need special protection, and you don't act thereafter, you keep quiet thereafter, that is omissive discrimination, how the court has explained it. Now, in the case of Transgender Persons Act, now the 2019 Act, which comes into force in 2020 after the judgment in 2014. Now, the Act seeks to, on paper, seeks to provide various rights, that you will have a right to employment, you will have a right to welfare schemes, you will have right to education, you will have right to household. Various rights have been provided under the Act. But the implementation of this is all left to be done subsequently, either under the rules or by policies that the government will form. Now, we are today in 2025, and the absence of policies, and think about it, 2014, the Supreme Court, one is late in the day, but still, the court recognizes that transgender persons have, the state needs to do something positively for the rights of transgender persons. Now, from 2014, we are 10 years down the line. From 2019 or from 2020, we are at least 5 years down the line. The state doesn't do anything. So that itself is omissive discrimination. So in such scenarios, the state cannot come to court and say, see, we passed an act. See, we've passed the rules. And therefore, we have complied with our constitutional duty. The constitutional duty does not only limit itself on passing of legislation, it proceeds to implementation of those legislations. And in this case, that implementation is lacking because, take for example, now in the case of Jane, we'll take it factually. The law says that there will be no discrimination, specifically prohibits discrimination. The rules provide that there will be prohibition of discrimination. There's, in fact, there's a specific penal offense which has been made out under the Act. But where does a transgender person whose rights are violated, in this case, as Jane's rights, she was discriminated and terminated from one place and in the other not allowed to join. Now, where does Jane go to enforce those rights? Now, if she goes to, take for example, she goes to a lawyer, the lawyer tells her that this is an employer-employee dispute. She says, what are my rights? File a civil suit, which means it'll take 10, 15 years because of the dockets of our courts, which are already flooded. So when does she get justice? What does she do with her rights? So therefore, I think it's the court again has recognized it and put it specifically under this head, and which will help in future, I think in future litigations also, including like in the case of persons with disabilities, for children, when we are thinking about rights of children, again, pollution matter, environmental matters, where the state sometimes just shuts its eyes to the pollution, like take for example right now in Delhi as we are facing. So these are aspects where again this judgment or this concept of jurisprudence will now be put into use.
Thanks a lot, sir. I mean, it's a great, kind of a revision exercise also for our students who've now gotten to see how this concept has been developed over the years, even though it didn't have a specific name to it. And now, it has been placed under one particular name. If I may just add a little bit about the journey of this particular law. I mean, certainly we are all very well aware about the Nalsa judgment, where the court, directed the government to come up with the rights-based legislation. I mean, one can see similarities even before the law was enacted, how the process of consultation happened. There was a serious lack of commitment in that sense of being very inclusive of even the during the process of drafting the law. And this is something also which Professor Deepika Jain has documented in one of our papers. How it was a violation of pre-legislative consultation policy, and that's why you end up with a law which is also not fully meeting the needs of the community. And even if we had a law, a rights-based law, there are serious, problems in terms of its implementation, as we observe with regard to other, human rights laws as well. So it's a very useful concept. I hope that with this particular doctrinal shift that we've seen as a consequence of this judgment, it becomes more useful for other human rights cases that we are going to see in future. Um, Anubhav, did you want to jump in here? Yeah.
Yeah, I had a few questions, and we'll end with those. One is, I think I'm talking for my students, and also this question comes up not from non-lawyers a lot. So the court gives this great judgment in Nalsa. You have a law first after 5, 6 years. This is a pattern that the legislature and the executive always sit on it on human rights issues, or once they somehow cross the legislature barrier, then they don't implement properly. Why do we see this? Is because this seems to show that judiciary has to first direct, then it has to examine the law, then it has to examine the implementation. Ideally, this is not judiciary's work, but why is this a repetitive pattern, sir? In your opinion, whatever you would like to share on this.
So this is slightly outside the legal framework. It's more on the political will aspect, I would put it. What
Yeah.
has happened is over a period of time, we've not had political will on certain issues
Mm.
which which do not drive votes. Let's put it as simply as
Mm. Correct.
where you have where you have votes where it will impact aspects, you will find that there will be people, as in you'll find laws coming in, you'll find a force to implement them, like in the case of say reservations, how we've
Yeah.
sought to now dilute reservations. What was the concept under our constitution? Which were the marginalized groups that the original constitutional framers wanted to protect? And what we want to do to that, and how we want to, by a side wind, undermine that.
Mm.
Though recently those amendments have been, the constitutional amendments have been upheld, but the laws that have been sought to be brought in again and again have been tested in court and thankfully those laws have been held to be bad. So you see, it's always about political will. When it comes to certain aspects, it is always that what is driving because our legislature is, we are putting them in, we are voting for them and we are putting them in parliament. So it's only once, I think, that more the people get to know about their rights, more the people, as in, if people seek to enforce their rights and ask these tough questions to their lawmakers, I think we will see a change. But otherwise,
Yeah.
over a period of time, this has been something that we've always had to face. Thankfully, we've had, from time to time, the Supreme Court coming up with great judgments which help us believe in our constitution.
Yeah. Yeah. No, and I would say this judgment is probably one of the judgment of the year for sure, if not for some time. I just want, you have alluded to this, the potential impact of this judgment to persons with disability, children, even environment matters.
Yes.
Uh, do you see that now, at least after this judgment, we are squarely in the substantive equality arena, where state now cannot ignore its positive obligations on non-discrimination, and this leading to a flood of good litigation in other matters also because of this judgment?
Yes, so I think one is substantive rights, absolutely. And like I said, this is one of the way in the line of judgments uh, on indirect discrimination or substantive, where you have to bring about substantive equality and not formal equality. We have a line of judgments and good jurisprudence laid down by Supreme Court, Jane Kaushik being the latest of them, I would say. But what this judgment brings about is, I think it empowers marginalized groups, any marginalized group, to come to court against systemic neglect. So that aspect, I think this judgment brings out very well, and that this judgment should help other litigation wherever there's systemic neglect, whether it's tribal persons' rights, where or forest dwellers' rights. We've had in the past courts talk about, the issue pertaining to, take for example, where tribal persons are there, when mining is to take place within certain areas, uh, you should take concurrence of those persons. We've sought to uh, even under the Panchayat Schedule Areas Establishment Act, etc. Again, we are supposed to do that, but most states are not implementing those.
Yeah.
Now, this judgment can gives gives those persons a right to go to court and say that once we have the 73rd constitutional amendment, these are and you tie up those rights under those acts to your fundamental rights, you can force the state to now implement these laws. See, because otherwise, traditionally, the Supreme Court has always said that the court cannot legislate or the court cannot direct the legislature to legislate.
Yeah.
But you see, these are small steps that the court is taking towards now correcting that, because over a period of time, like you said, we've not had the political will to bring about certain changes. So sometimes the court then has to step in. Like I said, from Vishaka onwards, whenever there's been such a lacuna, the courts have stepped in.
Yes, completely agree. And I will just end with this question where this case and your association is also a prime example of an academic research institution where I'm sure you've worked with professors, research associates, and students. Their work would have also fed into your strategy, your research, etc. So here we have a constitutional law society also. It's at a very nascent stage. But it would be lovely if you can give a message out to them how they can actively be involved with the Constitution, which we are seeing in this case, for example. That would be great from you.
Yeah, so this case actually would have not been possible for me without the help of CJLS, including my juniors and lawyers who work with CJLS. Like I said, CJLS runs a legal aid committee, and had lawyers who were there who were researching on various aspects. Also, like I pointed out, the importance of working with academics is in this case CGLS working with the people on ground, and therefore having the ground realities where which could be brought before the court. That is one huge benefit. Secondly, I would put it that as academics, my language I was clear on how to address these issues, because, like I said, sometimes we are cavalier with how we approach an issue. We may rely upon old languages used in court. Like, take for example, though Nalsa is a judgment which recognizes the rights, but if you read the language, it's still it's problematic because of the use of certain terms which we would not want to use. So therefore it becomes important. So these kind of inputs come from other people, because otherwise when we are in court, as lawyers, we get restricted sometimes to our own briefs. So these inputs become important to increase the overall jurisprudence and the understanding of the issues. And students can help because they bring about, they see things with a fresh pair of eyes. Sometimes we when you are a regular practitioner, you start looking at things in a particular manner. So students being involved with this kind of litigation will always bring in new perspectives. And sometimes, if the students themselves, say, take for example, from one of the marginalized communities, they bring to fore their own lived experience, and that helps, understand issues. Because sometimes, like I said, when you are from a privileged community, you've not seen that aspect. You've not seen the struggles. You've not seen how the law is implemented. So you don't understand those aspects of the law, and all this really helps to bring out an overall case and help in improving the jurisprudence of the country.
Yeah. Thank you so much. So that was an enlightening session. Honestly, we couldn't have had a better session on Constitutional Law Day. And we are very, very thankful to you for taking out the time, I'm sure, from your busy schedule. And like I said, we really look forward to hosting you in person and talking to our students. I think that would be a great opportunity for them. Until then, thank you so much, sir. Thank you.
Thank you
for
so
having
much, sir, for acknowledging all the work of the students and the academic center at JG also who you worked with. This is great, and I'm sure like this students will find this very encouraging. Maybe we can also like take a moment to recognize the importance of this judgment in this year, particularly where globally around the world when we see there is a huge movement against transgender persons' rights, and this judgment certainly brings a lot of hope, and this is something which is being received very well across the globe. So congratulations on securing this judgment as well, and yeah, we really hope that the petitioner in this case gets better protection in her employment in future. So
Hopefully.
thank you so much. Thank you so much, sir, once again.
Thank you. Thank you.